Greetings, class. What we'll talk about today in Chapter 10 is some of the core elements of an agreement, a contractual agreement. And those two elements are offer and acceptance. That's what I'll talk about for this portion. This chapter also includes consideration, and I'll do a separate recording for that. One of the key concepts for contract law is the idea of the objective theory of contracts. Now, we already know from a CAF, remember that? Um, we know from a CAF that a contract requires mutual assent. And in case you didn't remember, a CAF is the mnemonic that I recommended that you use to remember the elements of a contract. So a contract does require mutual assent, which is an agreement. And in the law, the way we tell whether there's an agreement is we look at whether there's an offer and an acceptance. Now, to make it legally binding, we also need consideration, but that's something we'll talk about in the next recording. So whether an offer has been made then is dependent on what a reasonable person might believe in the context. The facts are key, so you look at the words used and the circumstances in order to determine whether there's a contract that's been made. The objective theory of contracts is different than subjective. And what we mean in the law by objective is that you look at it from a reasonable person context. In other words, it's not what the actor, what the person was thinking. It's it is how a reasonable person would interpret that conduct, and those circumstances in figuring out whether a contract exists or not. So again, I want to emphasize that. I know it seems like it's subjective, but the idea is that what makes it objective is that the law determines whether an offer was made or whether a contract exists. The law determines it by standing outside of the person or people who are acting and kind of looking at them and asking, well, how would a reasonable person interpret this? Not what were those actors thinking, but how would a reasonable person interpret this? Is this the kind of situation where a reasonable person would say there's an offer or there's a contract? Or would a reasonable person say, oh, it's clear that that's not a contract? That's the question the law has to ask. And part of that's because we can't get inside someone's head and know exactly what they were thinking at the moment they made an agreement. We can only go by what they did and said and wrote. So we're going to start with a couple of review questions. And as I did with the presentation on Chapter 9, I'd like you to stop and think about these. Answer them yourself, and then we'll go on. So pause this for a minute or so and answer the question, and then we'll come back and I'll give you the answer. So the two questions: newspaper advertisements are generally valid offers, true or false? To determine the validity of an offer or acceptance, the test is generally what a reasonable person would have understood, true or false. Now for the answers, hopefully you got them all right. But if not, you know what to review to make sure that you understand it more clearly. Newspaper advertisements are generally valid offers? No, they are not. Newspaper advertisements are invitations to make an offer. And then the offer is made when the person, the individual, the customer, goes into the store and selects something and then goes to the cash register to buy it. So if we take the example of going to buy a car, I'll pick something large. You see an advertisement and it says this car is on sale for $10,000 and normally it's $12,000. So you go to the car dealership and you pick out the car, and then you present your money, a check, or you present a contract from your credit union or from your bank, or you sit down with the dealership and agree that you're going to sign a contract to buy the car. That's the offer. The acceptance is when the salesperson says, okay, thank you, and takes your check and gives you the keys and all that. That's the acceptance. An advertisement is an invitation for offers, but advertisements themselves are not offers. Now, what some people may question is, well, what about all these advertisements where they say it's quantity limited, etc. Well, they have to. The sellers have to say that. Commercial sellers have to say that because the Federal Trade Commission has adopted regulations to prevent false advertising. And you know, for your first online discussion or second online discussion, you've been talking about the Federal Trade Commission. So, so the Federal Trade Commission puts restrictions on advertisements. And then the second question, to determine the validity of an offer or acceptance, the test is generally what a reasonable person would have understood. Now, I hope all of you got this one right because I was just explaining that, and I spent some time explaining that. So hopefully all of you answered true on that one. If you didn't, go back to the book, review it again. So what's an offer? An offer is a proposal by one party to another that indicates the offeror's present intention to be bound to do or not do something in exchange for a promise or an act from the other person. That is one definition of an offer. And look in the book to find other definitions. The picture that I have on this slide is a picture of a house for sale with a sold sign on it. Now, if there was no sold sign and it just said for sale, that's an advertisement, which is an invitation for offers. So then prospective buyers go and tour the house, and then they make an offer. And they make it in writing because real estate, generally, you have to have written contracts, not oral contracts. So they make a written offer. And then it's up to the homeowner who put up the sign to decide whether to accept or reject that offer. So the sign is not an offer. The sign is an invitation for offers. The buyers who come in and look at the house are possibly going to submit an offer. Then if someone does submit an offer, the homeowner has the right to accept or reject the offer. And apparently from the sign, the homeowner accepted the offer because the house is marked sold. So what are the requirements of an offer? Well, again, using the reasonable person standard, there must be a clear intention to contract. The offer must be definite, although Article 2, UCC Article 2 relaxes that a little bit. And you'll see reference to Article 2 throughout the chapter, especially at the beginning of 9, but also all through Chapter 10. And then communication of the offer. The offeree has to know about it in order to accept it. Now, in terms of intention, we're going to take a little bit of a look at that. And then communication, it may make sense that the offeree should know about the offer in order to accept it, but sometimes in the case of offers to enter into unilateral contracts, like rewards, someone may do something that would entitle them to a reward, but if they don't know about it, they don't get the reward unless the reward is a government reward. Okay, so let's go through some questions again. Let's see. Okay. So I thought I'd left off the answers, but I have the answers on the next slide. So again, read through these questions. I'll read through them real fast. Then I want you to pause it, answer the questions, and then we'll go through them. First, the common law of contracts controls contracts for the sale of services. 2, true or false, the courts use different rules to determine whether mutual assent has resulted in a contract when the proposed contract is a goods contract rather than a common law contract. 3, under the common law, if essential terms of a contract are left open, there is no contract. 4, true or false, the mirror image rule requires the terms of the acceptance exactly match the terms of the offer. And then 5, is a scenario question that is not, which is a short answer question. Adam informs his 2 friends that by pretending to offer his '85 Honda for sale at $1,000, he can get Baker excited. Baker listens to the offer, is excited over the bargain, and says that he accepts the offer. Adam can prove that he was joking and wasn't intending to make an offer. Could Baker prevail in a suit for breach of contract, and explain? So pause it. Okay, you've paused it, answered it. Now here are the answers to these questions. The common law of contracts controls contract for the sale of services. That one is true. And I'm sorry, I meant to delete the page numbers. This is from another book. So just ignore the page numbers. It's going to be different pages on this book. So you can find those page numbers, and if you want to post something about it, that'd be fine. That is true. Common law of contracts applies to sale of services. And then the UCC Article 2 applies to contract for the sale of goods. The second question, the courts use different rules to determine whether a mutual assent has resulted in a contract when the proposed contract is a goods contract. That would be UCC Article 2, rather than a common law contract. And that is true. As you went through Chapter 10, you saw that there are references to Article 2 transactions, and those are goods contract. Those are goods transactions, or contracts for the sale of goods, and they are different rules. 3, under the common law, if essential terms of a contract are left open, there's no contract. That is true. That relates to the mirror image rule, which is the next question. If essential terms are missing, then the common law says, okay, no contract. Under Article 2, there could be a contract if there are just a couple of terms there, just enough for a court to figure out whether there was an agreement. Those are usually the subject matter of the contract and who the parties are. And almost everything else, the court will say, we can figure that out. 4, the mirror image rule requires that the terms of the acceptance exactly match the terms of the offer. That is true. And when you think about it, mirror image means the offer and acceptance look the same. That applies to common law, though. It does not apply to UCC Article 2 contracts. And then 5, Adams made this joke to get Baker excited. Baker says, hey, sounds great. Adams says he wasn't joking. Could Baker prevail? Yes. If a reasonable person would have understood that Adam was joking, then subjective intent is irrelevant. Although this is a goods contract, under both, the offeror must have an intent to make an offer. So you have to look at the circumstances. Baker could prevail if Baker can show that no one would have understood that Adam was joking. However, if a reasonable person would have thought that Adam was joking, then there would not be a basis for Baker to sue. Okay. Now I'm going to just go quickly over situations where there's not really an offer. Sometimes parties sign an agreement to agree. Those are not considered offers. Sometimes people give statements of opinion. Doctor says, oh, I think you'll be fine. That statement of opinion is not an offer. Preliminary negotiations or haggling or bargaining, kind of negotiating, those are not offers. They're still, a process of negotiation. Advertisements are not offers. I've talked about that already. There are some exceptions, but the general principle is advertisements are not offers. You have to look and see if it's very specific, then maybe it would be an offer, but normally it's not. Auctions, who's the offeror in an auction? The offeror is the person who's bidding. Now, I do want to talk just briefly about UCC Article 2, contracts for the sale of goods. This picture that I have is intended to represent things that would be goods, because the key definition of goods is movable, tangible property. So let's look around in this picture and see. You've got a chair, you've got box, you've got drawers, looks like tables, pieces of a fence, papers, clothing. It's a mess, but I wanted you to get the flavor of what goods are. And these things are all goods. as opposed to non-goods would be intangible things and services. Those are non-goods, and real property. Those are not goods. But things like this that are in this big junk pile, those are considered goods under Article 2. And so the rules for interpreting those are different. Now the book talks a little bit about when an offer terminates. How long does an offer last? The picture that I have on here is like, okay, this is the end of the offer. It lasts until it terminates or is accepted. And so that's what the picture is designed to try to show. Now, an offer can terminate in a number of different ways. I'm just reviewing these really quickly, and then when I finish with this, go back to the book and review it again if it's unclear to you. So an offer can lapse by the terms of the offer. Let's say that I offer to sell you my car, and I say I'll leave the offer open until tomorrow at midnight. Then it automatically ends tomorrow at midnight. I don't have to call you up and say, hey, my offer ended. It just automatically ends. Or a reasonable time if we don't state it. And a reasonable time depends on what the topic is. If it's a contract, an offer to sell eggs, for example, eggs are perishable. So that offer would terminate relatively quickly, maybe a few days, a week. If it's an offer to sell a car, it might last a couple of weeks. If it's an offer to sell a home, then it might be up to a month or 2 months. That's how the court determines a reasonable time. Also, the law terminates an offer if certain things happen. If, for example, what you're offering to do becomes illegal. No one has to say anything. It's just that if now I offer to sell you my car for $500, and while the offer is pending, the legislature passes a law that says no cars can be sold for less than $600, then my offer automatically becomes invalid. It terminates. I don't have to call you. You don't have to say anything. It just is automatically illegal to sell the car for that price. Death or insanity of the offeror terminates the offer. Also, destruction of the subject matter. So if, again, I offer to sell you my car for $500 and you're still thinking about it, and let's say that I make the offer at 1 o'clock in the afternoon, you're thinking about it. At 3 o'clock, you call me or send me a letter or something and say, you know what, I do want to buy your car. And I say, okay. We walk out to complete the transaction, and unknown to us, at 2 o'clock, a tree fell on the car and crushed it. The offer that I made to sell the car actually terminated at 2 o'clock, even though I didn't know and even though you didn't know, because the subject matter was destroyed. Okay, the offer can also terminate if it's revoked, and revocation is when the offeror withdraws the offer, pulls back the offer. That's what revoking is. There are special rules for options and for firm offers, and also promissory estoppel, which technically isn't an offer, but it is a principle for holding someone to an offer. So go through that in the book. I'm not going to go through all of that today. If the offer is rejected, that means the offeree says, no way, I'm not interested. Then that terminates the offer. Also, a counter offer terminates the offer. Or if the offer is accepted, then obviously there's no longer an offer, it becomes a contract. So what's acceptance then? So we've looked at what an offer is, what the elements of an offer are, how you can tell that whether there is a real offer or not, when the offer ends, and now we're looking at what constitutes acceptance. And acceptance is the offeree assenting to all the terms of the offer, demonstrating an intent to be bound, an intent to make a contract. The mirror image rule mentioned earlier applies if it's a common law type of contract. That means it's not a goods contract. And the mirror image rule, again, just says the acceptance is the mirror image of the offer. The manner of acceptance is controlled by the offeror, but if the offeror doesn't say anything, then it's got to be reasonable. If the offer is mailed, then the offeree can mail back the acceptance, and the acceptance is valid as soon as that's mailed with the proper postage and with the proper address. However, offers, revocations, and rejections have to be received before they are valid. Now, if an acceptance is sent by an unauthorized method of communication, then the acceptance isn't valid until it's received. And then silence normally is not an acceptance. So we're going to go through a few review questions to just wrap up this part of the discussion of contracts. 2 questions. Con mails out 100 letters to various people, offers to sell them a widget for $100, and warns that if I don't hear from you within 30 days, I assume you have accepted this offer. Enclosed is a stamped self-addressed envelope for your answer. If no one responds, does Con have 100 contracts for widgets? Explain. And then the second question is, a developer offers a house painter $600 per house for the 4 houses he will paint. $500 in advance, the balance on completion, and work to be commenced this week. The house painter replies in a number of ways, and then I want you to classify each response. What does no mean? What does yes but mean? What does sound okay mean? And what does yes is it okay mean? So again, please take the time to pause the video and answer the questions, and then listen to the responses. Okay, hopefully you did that you paused it. So Con mails 100 letters to various people, offers to sell them, and says, if I don't hear from you, I have a contract. Does he have a contract? Explain. And I put no, but I didn't put an explanation here. Oh, that's funny. Okay. So why doesn't Con have contract for the widgets? What he sent out is invitations for offers, and silence is not an acceptance. So what Con's trying to do is to say, if I send this to you and you don't answer, your silence means you're accepting it. The law says no. Silence is not an acceptance. So here where it says no, add in, silence is not an acceptance. Now, some of you may be thinking about those radio club, or CD clubs or book clubs, where, you get like 10 books for a penny, and then they'll send you 1 book every 3 weeks, and if you don't tell them, or they send you a notice that they're going to send you a book about every 3 weeks, and if you don't tell them that you don't want the book, then they will just send you the book and then bill you for it. Now, why is that different than this situation? The difference is, in those clubs, when you take the 10 books for a penny, a term of that taking is that your silence is an acceptance of each book unless you reject it in time. So that differs from this, because here he's just sending it to people. They haven't agreed that if they're silent, they'll accept it. So that, in the situation with Con's out of luck. In the situation with the book club, the people who signed up for the book club have to pay for the book if they don't reject the book in time. So that's the difference. They agreed to that. And then for the second question, several different responses. A rejection is no. That's when the offeree says, I'm not interested in this contract. When the house painter said, yes, but 1,000 down, that's a counteroffer. He's agreeing to the terms of agreeing to the payment terms, but is not agreeing to all of the payment terms. So he's said, yes, but, which kind of negates any acceptance. He's saying, I will only do it if you do it my way. Now, if he says, sounds okay, but can you raise it a bit? That's more of an inquiry. Like, oh yeah, I'd like to do it, but I'd like you to give me some more money if I can get it. It's not a counteroffer. The difference between a counteroffer and an inquiry is that a counteroffer terminates the original offer. Whereas an inquiry basically you have kind of two almost offers pending. One is the original one, 600 per house, 500 advance, balance on completion, work to commence this week. The other is sort of an offer, not exactly an offer. And the other, because he just says, can you raise it a bit? Doesn't give any numbers or anything. So it's an inquiry. It didn't terminate the original offer. Whereas the second one that says yes, but 1,000 down, it's like, I don't want to do it if you don't give me 1,000 down. So it's the yes, but is what controls it. So that's why you have to read really carefully. And then the last response, yes, is it okay if I begin next week? That's an acceptance, because he says yes, period. Then the question is, would you accept if I begin next week? If the other person, if the offeror says, I want you to start this week like I agreed, then the house painter has basically agreed to that. It's just asking for a little wiggle room. So that covers this chapter. Hopefully this will help you as you're reading and understand, and help you to understand it. Hopefully you've already read it as you're reviewing it. Okay,